Hi, everyone. This is Debbie Gatte with the Philanthropy Roundtable. We are back for another edition of Can We Talk About It? And today we have a distinguished professor of law who focuses on First Amendment issues from UCLA, Eugene Volokh, with us. And he is also the founder and frequent contributor at the Volokh Conspiracy, which you can find at reason.com. And the description for that publication blog is, I love it. It's mostly law professors, sometimes contrarian, often libertarian, always independent, and established in 2002. Eugene is also, I think, the best virtual cocktail host I have come across since the world changed and we all started to do things virtually. So it's another qualification of his that I wanted to mention. But welcome, Eugene. Thank you for coming on and talking with me today.
Thank you very much for having me. A great pleasure to be on.
All right. Well, there's a lot to talk about, but there is a particular angle that you are working on that a lot of people who are thinking about free speech and also thinking about division and all of the call out culture and the naming and shaming, all of this language that we're hearing. You're working on an aspect of it that many people may not be thinking about, and this is the libel aspect, right? So a lot gets said on social media, a lot of words get thrown around. People do say awfully mean things sometimes, and they do say things that they hope will shut someone down. What is the relationship? Can you walk us through the relationship between law, libel, social media? What has changed? Should it change? Libel, I think, is something we're used to thinking about. You print something in the newspaper and it's not true, and therefore, someone can start a lawsuit for that. But tell me about libel and social media and what is changing.
Sure. So the First Amendment protects a very broad range of speech, protects opinion, protects true statements, protects statements that are intended to discourage other people from speaking. So if you want to organize a boycott of someone based on their speech, that organization is itself protected speech. It doesn't protect false statements of fact, especially knowingly false statements of fact, but about private figures, even negligently false statements of fact. That's a pretty narrow exception. A lot of stuff that's said online that people find particularly upsetting is opinion. Calling someone an idiot, saying this person is evil and ought to be fired, even calling someone, say, a white supremacist or a racist. Courts have generally said that those are such rhetorical terms these days that they're usually empty of any sufficiently concrete meaning to be factual enough to be libelous. Now, accusing someone of specific actions, oh, this person fired an employee because the employee was black or white or whatever else, that might be libelous if it's false. But general pejoratives, by and large, at least many of them, are not libelous. They could be actually quite offensive to people. They could be quite damaging to people's reputations because expression of opinion can damage someone's reputation. But under modern libel law, they are not legally actionable.
So someone could call a colleague a white supremacist and make that accusation in the workplace, and it could even lead to somebody's termination at the workplace. However, that expression of opinion and that label, there'd be no remedy for the person who is forced to depart from that job.
Well, that's right, because the employer in a private workplace is generally free to terminate the employment relationship because they think this person is evil or racist or whatever else. And if that's so, then somebody urging others to do that, that's fine too. Again, urging using false statements of fact, that is libelous. Mm-hmm. But in the absence of that, just sort of expressing an opinion, whether it's, I think this person is a racist, or I think this person is a fool, saying, I think this person's work is just shoddy, as a general matter, at that level of generality, is probably going to be opinion and is not going to be libelous. Now, in a considerable number of states, firing someone for their political activities, and different states define that more or less broadly, is indeed legally actionable. It's prohibited by state employment laws. So for example, in my state of California, employers, even private employers, are prohibited by law from firing employees for a broad range of political activities, not just campaigning for someone's election, but for expressing political views. So there, the employer might be restricted, but urging someone to fire someone, generally speaking, probably, at least in states where such firings are legal, would certainly not be actionable unless, again, it contains a false statement of fact.
Got it. So it is a very narrow exception. The libel law is very specific and very narrow exception. And nothing that we've seen in the social media, the development of social media, the fact that we have now all these different channels where people are much more readily making comments about one another. The law has remained fixed, even though the activity in the sphere of dialogue, discussion, insulting, offending has gotten bigger. Did I get that right?
Yes, that's quite right. And one thing to keep in mind is defamation law, including specifically libel law, which has to do with written defamation, has never been limited to, say, mainstream media. A lot of the lawsuits have been against major newspapers because that's where historically libels have been most damaging, and also they have the money to pay a libel verdict. But traditionally, writing a letter to someone, classic example is writing a letter to someone who's about to be married, saying that his or her fiance has been unfaithful. That could be libel. There were libel lawsuits for that sort of thing. So from a libel law perspective, there's really nothing that new as a matter of kind, as opposed to a matter of degree in a lot of these online libel situations. I do think that there have been some shifts in libel law having to do with remedies. So for example, up until around the 1960s, maybe 1970s, it had been broadly accepted that you can't get an injunction against libel. You can get damages, but you can't get an injunction. Then starting with the 1970s, some courts started to shift away from that and say, no, injunctions are okay. In part because there were, even before the internet, situations where defendants could do a good deal of damage to the plaintiffs and yet not have any money to pay a libel verdict. So somebody, let's say, protesting outside of some business, making allegations that might be factually false. I think the internet has accelerated that. At this point, 2/3 of the states allow injunctions in at least some kind of libel cases, and fewer than 10 states forbid them. The remaining ones haven't really considered the issues squarely enough. And I think it's in part because now it is possible, in fact, quite easy for people to damage somebody's reputation through false statements, even though they don't have any money. They don't have to own a newspaper. They don't have to have the ear of a newspaper editor. And even if they post something and that doesn't get a lot of readers right away, there's a steady drip, drip, drip of damage every time somebody Googles the person's name and sees this libelous allegation. Likewise, we're beginning to see a little bit of a revival, still a little bit, but a little bit of a revival of criminal libel law. Criminal libel law used to be very common. Criminal libel prosecutions used to be very common in America from the 1700s to the early 1900s. Then they started to become less common. Conventional wisdom when I was going to law school in the late 80s and early 90s was basically there were no libel prosecutions. But turns out there are. About a dozen states still have criminal libel statutes. So probably 20 to 30 such prosecutions in the country. Not a large number, but they're there. And there's some indication they're on the upswing. And that even some states are reinventing criminal libel law through use of other kinds of provisions. And again, I think that's a reaction to the sense that civil libel damages, never terribly effective at stopping libelers, have become even less practically effective.
Well, this is an area I have not been following, the criminal libel prosecution. So what would qualify for a criminal libel prosecution versus a civil case? What would qualify for us to understand this?
From a purely legal perspective, the Supreme Court has said that anything that can be punished as civil libel, especially through punitive damages and not just compensatory damages, can also be criminally punished. So as a general matter, between the First Amendment rules and the normal provisions of libel law, it has to be basically knowing falsehood that damages reputation. Honest mistake is not enough. Usually honest mistake is not enough in general for criminal prosecutions. If I walk off with your umbrella, and I think it's my umbrella, that's a classic example in criminal law, I'm not guilty of theft because it was an honest mistake. Likewise, an honest mistake usually wouldn't, or at least in all the statutes that are on the books to my knowledge today, honest mistake isn't enough for criminal libel prosecution, but a deliberate lie would be. Now, as a practical matter, of course, in a criminal libel case, as opposed to a civil libel case, you have to persuade, you as the libeled person, allegedly libeled person, have to persuade the prosecutor, even in states that have criminal libel laws, to take time and effort to prosecute. And in many situations, prosecutors would say, this is something you should file a lawsuit over. But in some cases, there are such examples, especially where it looks like a civil lawsuit hasn't stopped someone. So sometimes it's things like a jealous ex posting very serious allegations of sexual misconduct against the ex. In some situations, it's people like crazy neighbors saying, or at least what looks like crazy neighbors, saying nasty things about others out of revenge. In a few cases, I have seen it used for political purposes. So, for example, there was a case in Louisiana where there was somebody saying things about a local, I think it was a local politician and business leader. And there were criminal libel charges filed, as best I could tell, chiefly to unmask the anonymous speaker.
Oh.
It seemed pretty clear that the criminal prosecution would go nowhere because Louisiana criminal libel law is actually defined very narrowly. But it looked like the goal was just to use the procedures of the criminal justice system to try to get subpoenas and try to identify who the speaker was. So this is certainly something that can be abused. Many laws can be abused, but if one views reputation as, I oversimplify here, but as a valuable part of someone's property, one views libel as essentially a kind of theft of reputation, or alternatively, you could view it as fraud. Right. Now, to be sure, not financial fraud that seeks to take money from the listeners, but nonetheless a kind of fraud that seeks to lie in order to get listeners to stop doing business with someone or stop socializing with someone or the like, then there seems to be some need for a viable remedy. Yes, and as I said, civil damages in many situations are not a viable remedy.
Wow. Well, that I think is this is very important information for people to understand as they think about, their interactions in social media, and they think about what, what the actual law says about what can and can't be pursued for libel. But let me ask you about another line that I think sometimes is confusing. Libel and then harassment.
Right. So harassment is not, I'm sorry, go on.
Go ahead. No, I was going to say, so how should we think about harassment online?
So harassment is not a well-defined term. It's not a well-defined term, I think, in ordinary discourse. It's not well-defined in the law. There are different kinds of things that are called harassment in law, and they also vary sharply from state to state, as opposed to libel, by the way, which is pretty well settled what the rule is. So, for example, here's one classic example of harassment: telephone harassment. If I call you up and say offensive things, or maybe even call you up at inconvenient times, call you up and engage in heavy breathing, let's say, that's something that historically has been criminally punishable. And I think the rationale for why it's constitutional, and most such laws, not all, but most of them have been upheld, is if I'm just talking to you and you don't want to hear it, either because you've told me to stop calling or because it's obvious that you don't want to hear it, nothing much is lost to public discourse from saying, look, Volokh, go talk to someone else who might be interested in hearing. Maybe they are, maybe they aren't. Talk to the public, of whom maybe only 1% is interested in hearing, but don't talk to this one person who has said, who has said, stop talking to me, or who you're only trying to annoy and it's quite clear wouldn't want to hear from you. So that's been generally viewed as permissible. On the other hand, I've seen plenty of anti-harassment orders. I've litigated some. I've argued in the Ohio Supreme Court as to one that basically define harassment as saying offensive things not to someone, as with telephone harassment or email harassment, let's say, but saying offensive things about someone. And that, it seems to me, is fully constitutionally protected. Whether or not state law calls it harassment, the First Amendment treats it as constitutionally protected speech. There was actually a pre-internet case on this that we often cite in our briefs, Organization for Better Austin versus Keefe. It came up in Illinois. There was a real estate agent named Keefe, a civil rights organization, or at least a self-described civil rights organization, viewed him as engaging in improper kind of real estate activities aimed at harnessing and perhaps exacerbating fears of blacks moving into town, and there, as a result, white flight. So they started leafleting in his neighborhood, in his residential neighborhood, including by handing leaflets out to people going to the church that he belonged, condemning him. And it was quite clear they were trying to pressure him to change his practices. He went to Illinois court, which then issued an injunction stopping them from leafleting at all, although probably in context it meant stopping them from leafleting about him. And the Supreme Court said that's unconstitutional because speech about someone, even offensive speech, even coercive speech, coercive through the threat of social sanctions, is constitutionally protected. So that's, I think, an excellent example of how even if speech to someone can be punished. Just the year before, the Supreme Court had said that a law that allowed people who live at a particular place to say to mailers, stop sending me material, that was constitutional. So just as, while that is permissible restriction on speech to a person, you can't restrict speech about a person, even on theories of privacy or harassment.
That is fascinating. So that leads us to this next topic that we are hearing a lot about. Everyone's talking about cancel culture. Now, cancel culture, I guess, involves saying things about someone in a way that's intended to remove them from a conversation or to have some effect of silencing them. So is that a valid concept? And I'm thinking just what you just described in terms of what is permissible under the law and what isn't permissible under the law. What do we think about this concept of cancel culture? Is there a line between free speech that is between free speech and speech intended to shut down someone else's point of view?
As a legal matter, no. That free speech includes the right to advocate change, right? And one form of change is change aimed at stopping someone from saying certain things. So historically, the classic example has been boycotts aimed at, let's say, newspapers that publish something that people may find offensive. It could be offensive for all sorts of reasons. Back in the day, it may have been communist or racist or unpatriotic or anti-war or whatever else. Or even boycotts of other parties, let's say of advertisers, urging advertisers to pull advertising from some particular show. That is constitutionally protected speech. It urges, I mean, it's coercive in the sense that it tries to pressure people into changing their behavior, but lots of speech, many newspaper editorials are aimed at changing people into pressuring people into changing their behavior. More broadly, there's a wide range of speech that foreseeably stops others from speaking and perhaps intentionally and often laudably. In the academy, somebody writes an article that I think is wrong, I'll write a response and say this is why it's wrong. You know, I try to do it politely. I try to do it in a way that kind of promotes more dialogue. But surely many academics sort of, when they're about to publish something, they're thought as well, will other scholars condemn it as not as evil, but as wrong, as shallow? And if so, maybe I need to buttress this, or maybe I need to change my focus. And much of this is quite laudable, right? one of the things that makes a lot of high quality writing high quality is this fear that that other people will point out the errors or point out limitations in this, and that deters poor reasoning, deters erroneous argument and such. Now, sometimes it over deters. Sometimes somebody might say, I'm confident my position is right. It's well defended, but people will be so upset at it that I'm reluctant to publish it. That's unfortunate, but that just shows that the system of criticism of people for what they say has the vices of its virtues, but it definitely does have virtues. It maintains high quality of discourse. Occasionally, some people email me, say, Volokh, why aren't you covering topic X? And I say, I don't know enough about topic X to cover it on my blog. And they say, that's because you're afraid that people will criticize you. I say, I am afraid. I'm horribly afraid. I'm afraid of being wrong. I'm afraid of looking like a fool because somebody like you pressures me into writing something about the topic I don't really know much about. I don't want that to happen. But that's a good form of fear. More people should be afraid of looking like fools. That would be better, right? So that's why. So that's why, as a legal matter, urging, essentially trying to pressure people to stop saying things using one's own speech to pressure them is constitutionally protected. Of course, as an ethical matter, I think it's really quite complicated. A lot depends on the context. So, for example, when I teach my class, I'm trying to create an environment where people are encouraged to say things. And people being student people who aren't experts on it. I don't want them to be horribly afraid that anything they say is going to get mocked. And therefore, if a student does react really harshly to something someone else says, even if it turns out that the harsh critic is correct, I would say, look, let's talk about it in a more positive way. That's going to be more effective method for you to learn as future lawyers, and it's going to be more effective at promoting our discourse. Likewise, in some situations, if somebody is just aggressively trying to block speech that even is actually wrong, one might say, look, that's actually unproductive, because it's important to explain why something is wrong, rather than just calling someone a white supremacist or a communist or whatever, because that's what they say. So from an ethical perspective and a perspective of trying to maintain a helpful system for public discourse, I do think we need to think about a lot of these things. And I think this is, like many such questions, it's complicated. Again, some kinds of chilling effects are good, some are not. Hard to tell which are which. But from a legal perspective, there's no canceling speech exception to the First Amendment.
Right. This often comes up, right, where people blend the legal and the moral, and they confuse that those are two different questions. Something may be legal, but you still have the ethical, moral decision to make. And yeah, that is a helpful distinction on these matters. And of course, you want to have a setting in which your students can learn and in which conversation can occur, and learning can occur amongst the students as well. So that example is a good one.
If I can give another example of a benign chilling effect.
Yes.
I am often chilled from saying things that are really harsh or snarky on my blog. And part of it, I like to think, is I'm chilled because I'm a good guy. I like to think that. Others might not. But part of it, if I'm honest with myself, is I'm afraid. And what I'm afraid of is maybe I'm wrong.
Mm-hmm.
That is to say, maybe my criticism is actually mistaken. And it's so much easier to walk back criticism where you said, oh, I think this person might be in error for the following reasons. Then later on, you could just say, turns out I was the one who was in error. Thank you so much for this other person for correcting me. On the other hand, if what you say is this person is a horrible, evil liar, and then say, whoops, I read it wrong, my mistake, that's a lot harder, right? So it's another benign form of chilling effect. Sometimes we are deterred from being over harsh in criticism. We're being deterred from, in a sense, saying things that might over chill other people's speech because we're afraid, as we should always be afraid, that maybe we're mistaken. And, putting things in a more understated manner, a more polite manner, is usually safer, as well as probably being the right thing to do.
That makes complete sense. There is smart self-censoring.
Right.
And then there is self-censoring where you're allowing the pressure To
Right.
cause
Well,
you.
the sad thing is, unfortunately, they're sometimes smart but bad self-censoring.
Tell me
Some
more.
of the time when people censor themselves, it's not because they're dumb. They're quite
Mhm.
rational in fearing blowback from what they say. It's just bad for society that there's this amount of self-censorship. That's one of the things that makes it a very complicated problem.
Mhm. Yeah, people have shortcutted some of the thinking, on this, and lost some of the nuance. It's either cancel culture or it's not. It's either self-censored or it's not.
Right.
And what you're saying is it is more complicated. There are
Right.
times when it's a perfectly legitimate and wise approach to think about your words and to make sure that you're choosing
Right.
carefully. And in other situations, is it really a fear that's irrational that's holding you back from actually expressing yourself?
Right. Or as I'm pointing out, a fear that is rational from your
Mhm.
perspective, but that
Mhm.
is actually bad for
Or
society.
yeah, yeah,
If we knew that every time somebody expressed some view of, say, opposing affirmative action, they would immediately be subject to a boycott that would cause them to lose their job. It would be perfectly rational for people to stop expressing that view. It just would be bad for society that
exactly,
these subjects can't be honestly discussed.
exactly. That makes complete sense. All right, so let's take this to campus. We already talked a little bit about your classroom,
Mhm.
but on campus, there are lots of concerns about the state of free speech. But the campus is also a particular kind of institution. It has particular goals. It is there to carry out certain purposes. Um, from your vantage point as a professor, first, is it true that free speech is eroding on campus? That's the first question for you. And then, are there limits to free speech in the context of a university where the administration has responsibilities around maintaining the institution?
Right. So I do think this free speech has eroded sharply on campus over the last probably 5 years, especially. And I think that that's too bad. And I mean that both as to free speech as to on public university campuses, where I think some of the erosion violates the First Amendment, and free speech on private university campuses, where it's not doesn't violate First Amendment, but I think violates academic freedom principles. And more broadly, even on public university campuses, there's some of the erosion hasn't been outright constitutional violations, but it's still been bad for public discourse. Now, it is certainly true that on university campuses, like in other um, places, the rules of free speech vary from context to context. The chief distinction, I think, is between free speech within the context of a university activity versus free speech by students or faculty, but especially students, that's within the context of their just ordinary life in the university. So in the latter category, where speech is fully protected, I think needs to be fully protected, it's speech in the quad, in some open spaces. It's a speech in a student newspaper. It's speech, especially a student-run student newspaper, or it's speech of people who are having lunch together. That is fully protected. And the court has said essentially that the university, even though it's a property owner and it's running an institutional activity, doesn't get any extra power the way that K through 12 schools do, but the university doesn't really get any extra power to suppress speech there. On the other hand, let's look at the other extreme. Assignments for university classes. Nobody can say, I should grade my students' exams in a content neutral way, right? I mean, it would be easier for me. I'd count the
It
number of
would, it
words, right?
would.
It wouldn't be
Just give
good
them all A's.
grading.
Yeah.
I don't think they can even say that I can grade it in a viewpoint neutral way. I'll give you an example. Often in my law school classes, my exam problem is, here's a fact pattern. Make the best argument you can make for side A. And I say it for side A rather than choose the best side, precisely to make my grading fairer. I don't want to be in a situation where I'm trying to compare the arguments for side A from arguments for side B, where I might think one is stronger than the other, it becomes much harder to do it fairly and to compare the two. So I just say do it from side A. And I feel quite confident that that's a legitimate thing in law school to do, because as lawyers, you usually are told this is the side you're supposed to argue from. At the same time, my grading is by definition not viewpoint neutral, not just not content neutral, not viewpoint neutral. Because if you don't answer the question the way you're told to answer the question, if you make the best argument for side B instead of for side A, you're going to get marked down, because again, it shows you're not being a very good lawyer. So for that kind of thing, I do think there are important ethical academic arguments of academic ethics and of students' academic freedom that I shouldn't mark people down just because I don't like their position. But I have to evaluate what I think is, whether I think is a strong argument, what I think is a weak argument, and that's something that inevitably involves a lot of judgment. Another example in that area, although not exactly there, is in classroom discussions.
Yes.
When I'm curating a classroom discussion, in order to make the discussion work, I think I have to impose various civility rules. Mm-hmm. As a practical matter, I don't recall a single time in my 25 plus years of teaching where I've actually had to tell my students, stop being rude to each other. Maybe once or twice at most. In part because I think everybody sort of understands that as a norm. Maybe it's especially so in law school where the students are a little older and also understand that law is often about disagreeing in a way that isn't rude, that is mm-hmm. conducive to rational discussion. But if a student were to say something rude about another student, if they were to say that in a newspaper, this other columnist is an idiot because X. Well, they're perfectly free to do that, subject to the editorial judgment of the newspaper editors. But if they do it in my class, I'd say, look, don't do that. Don't call people names. Respond not to the person, respond to the argument. Okay, that argument is an idiotic argument. Okay, that's better. But don't just use labels, explain substantively this. If you're in court and the other side makes an argument, you're not going to persuade the judge or the jury by saying that's an idiotic argument, right? You could persuade them by explaining what's wrong with the argument. So I would do that. I would do that partly because it's important for me as an educator to educate students to make better arguments, and partly because I don't want other students to be unduly chilled. So the rules do have to be different. So I totally agree that the university has to have considerable authority, and everybody I think would on reflection agree that it has to have considerable authority over what goes on in the classroom. And usually, by the way, how is it enforced? If I see that a student is consistently being rude, if that were to happen, I would stop calling on them, at least for a while. And maybe I'll call them once and see if they've learned the lesson. I don't think they should be expelled from school. I don't think they should be disciplined for that. So as a result, I think a lot of these restrictions in class discussion don't have an undue chilling effect. They don't put people in a position where they're afraid if they say something, they might get expelled. The most that will happen is the professor won't call on them. Most students are just fine with that. But on the other hand, if the university were to say, anytime anybody expresses a rude view or a racist view or an anti-transgender view or an unpatriotic view or a blasphemous view or about someone, whether it's in the newspaper or it's in a rally or whatever else, then they'll be expelled. That is, I think, quite clearly unconstitutional in public universities and a violation of academic freedom principles in all of them.
That makes complete sense. I want to ask you about one other situation, and I see that I think you have some things that you need to get to as well. So I'll make this the last question, Eugene. What about when it happens from student to professor? So there are increasing numbers of cases where students are saying, my professor is not respecting my views. My professor is disrespecting me. I want some sanction against the professor. Do you have any thoughts on those types of situations where it's a student going in the direction of saying the professor is doing something wrong?
Well, I think a lot depends on exactly what the alleged wrong and the alleged disrespect is. And again, we can imagine a spectrum. So one thing, imagine a student says, my professor is grading me down because they know that I am a Trump supporter. So there's actually right now a controversy. There was a TA at Johns Hopkins University that posted a tweet that's the TA was, I think, in some engineering class, and the tweet said something like, should I mark down Zionists on exams that I grade? I don't know. And I think the answer is, if you don't know, then you probably shouldn't be a TA. And the university should be investigating to see if you are indeed discriminating, whether Zionist is code word for Jew, in which case it's discriminating based on either religion or national origin, or even if it really is just supporters of Zionism, discrimination based on ideology is just as unacceptable at the university as a matter of academic freedom as discrimination on other irrelevant bases. So in any event, that's one form of disrespect that really should be stopped by the university. At the other extreme, imagine somebody says, well, the professor said that he thinks that Catholicism has caused a lot of harm to women and gays and intellectual freedom in its history. Much of that probably is true. Not just Catholicism, a lot of religions.
Yeah.
Let's say atheists have had their own things to be blamed for. But in any event, the professor says something like that, and the student says, that disrespects me as a Catholic. Well, all right, but this is an important view that you can't expect the professor to be respectful of religions or ideologies in the sense of never criticizing them. What about things in the middle? So, for example, I think if a student asks a question and the professor says, that's an idiotic question, I do think that the university probably ought to have some degree of authority to tell this professor, look, you don't have to agree with the student questions. In fact, your job is to point out the errors. You should do it, though, in a way that is more polite, that's more productive of helpful discussions.
And more consistent with your role as an educator.
Right, exactly. Consistent with your role as an educator, because your role should be to encourage students to ask questions and to think through why the questions might be wrong, rather than making them fearful of asking questions. So I do think traditionally academic freedom has been understood as including the freedom to teach, the freedom of the faculty members to organize their classes and their pedagogical styles the way they want. I do think that might be limited when it comes to personal insults by professor against a student because of the student's views, let's say, or for other reasons. Because I think that is quite different from the professor expressing views about the subject matter, which I think are protected by academic freedom, even when those views are ones that many students might find offensive or might find that kind of might perceive as attacks on their identity. I mean, I'll give you another example. I give a talk about this very question of free speech on campus, and I talk about one particular incident at University of Minnesota, where there was an attempt to impose to find a poster which depicted the Charlie Hebdo Muhammad cartoon, find it to be harassment of Muslims, essentially on the grounds that it's blasphemous and offensive to Muslims. I think that, of course, it's not just constitutionally protected for people to put up such posters. I think it's the right thing to do. That this was an iconic image, the post mass killings at Charlie Hebdo image, an image that needs to be aired. But what if somebody says, well, Volokh is being disrespectful to me as a Muslim? I'd say, I understand you might find this blasphemous. I understand that many people of various religious groups are upset by blasphemy, but that can't constrain the academic freedom of professors like me, and also of students trying to do the same, to talk about this important image and display this important image in the course of talking about it.
Yeah. Now, there's so much to talk. I mean, this is the thing. There's so much to talk about, Eugene. We could actually do a part 2, I think, on this, just to understand. I mean, I think people need to understand what the law says and doesn't say, which is a big chunk of what we talked about. And then even if you have a law, you have moral considerations on top of legal considerations. And then there's the whole difficulty of implementing all of it in something as complex as a university. So really appreciate you joining me today and for all of our conversation. looking forward to the next virtual cocktail hour. And in the meantime, look forward to keep reading your work over at Reason.
Thanks very much for having me. It's always a very great pleasure talking to you.
Likewise, Eugene.
All the
Take
best.
care.
Thanks,
Bye.
bye.